slow. They heard you were coming and just revved right up.
We are live. We are
live. Like, okay, I just like applied for the permit. Here they are, but it's like, how come
Good.
it doesn't happen for everybody?
All right, we'll call the meeting to order at 7 o'clock. Could we have roll call, please?
Brian Card,
Here.
Virga Lawrence.
Here.
John Sarantopoulos,
Here.
Matthew Wendorf,
Here.
Michael Huco,
Absent with notification.
and Keith Thurlow.
Absent with notification.
All right, thank you. Item number 2, election of officers for this year. Do we want to table that till the chairman is here, or do we want to proceed?
I think we can table that until he's available.
Nothing says we have to do it tonight, right? All right, can we have a motion to table?
That you got.
All right, do we have a second?
Second.
All right, motion, second by John. All in favor, say aye.
Aye.
Opposed? All right. No addendums, citizens' comments, items not subject to public hearing.
The only citizen comment that we got was concerned a public hearing, but that particular public hearing, the applicant is requesting a continuance till June, so.
Okay.
And Mr. Chair, I'm just going to request to unmute the people that are on the phone just to make sure that they don't have citizens comment.
Does anybody on the live WebEx have citizens' comments of anything not subject to the public hearing?
If you do, just unmute yourself.
All right, I mean none. Item 7.
I already submitted a comment last time. I'm just here to listen.
Okay.
That's fine.
Thanks.
All right, item 7, number 1, zone map change, application 21-1278. Apparently we forgot to do a suggested effective date. So we have a suggested date of Monday, June 13th, 2022, 12:01 a.m. This was the map change that we approved last meeting. Do we have a motion?
Yeah, I'll make a motion to make the effective date Monday, June 13th, 2022 at 12:01 a.m.
All right, we have a motion by Virga. Do we have a second?
I'll second the motion.
Second by John. Any discussion? Being none, all in favor, say aye.
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 Opposed? None. All right, item 8. Public hearings, which one got moved? So I know. Or which one requested to be moved?
The one for
It's either 1 or 4.
Number 3.
number 3, Dayville Four Corners.
Okay, 4 or 3. All right. So item number 1, special permit application 22-1282, Jolly Commons LLC, 120 Regan Road, JS map 220, lot 21, 6.4 acres, general commercial zone, excavation removal of gravel products under section 560. Continued from last meeting, Mr. Norm Tebow, I believe.
Yes, sir, thank you. I do have some revised plans. So thank you for the record, Norm Tebow, Killingley Engineering Associates. The plans that Anne Marie is handing out have some slight modifications based upon a meeting I had.
Shall we share? Yes. All right.
We're good.
Okay, we're good. All right. The plans that you have in front of you have some minor modifications based upon a meeting I had today with Dave Capascione, where we discussed the drainage. When we left last month, it was requested that I provide drainage computations. I have a copy I'm going to submit for the record, but I did review them with Dave Capaccione this afternoon. And what we found, there really aren't any significant changes in the drainage due to the fact that we've got such well-drained soils out here. But for the 50-year and 100-year storms, in order to alleviate any kind of potential for runoff from the site out into the roadway, what we've done, and that we had before, we have this this broad infiltration swale along the front of the site that runs parallel to the roadway. So after discussing it with Dave, what I've shown on the plans is there's a series of berms within this swale to sort of kind of create these like little infiltration pools down the length of the swale. So as water comes, that section of the swale will fill up and overtop, and as you go down the line, it slows the flow down, gives the water an opportunity to infiltrate into the soil. Also, we thought it was a good idea because what we've got is a restoration mix on the cut slopes, but in the swale itself to kind of give the site a little better appearance and give it some, make it look like something rather than just an area that was excavated. I'm calling for a New England wildflower mix within that swale. So, that first 15 to 20 feet along the roadside, before you get to the cut slopes, we'll have those wildflowers there, and I think it'll look nice.
Can I raise an issue?
Sure.
May I? So I have my own struggles with seeding areas like that, and I would suggest that it needs to be done till it's done, meaning if stuff gets washed away, if seed doesn't germinate, whatever, get it done so that it's right, as opposed to make one effort, and if it fails here and there in patches, don't let it go. That's my only hope and suggestion.
We could certainly take that into consideration, absolutely. I mean, this is a quality seed mix. I've called it, it's from New England Wetland Plants. They make a lot of different restoration seed mixes, roadside matrix seed mixes. They're very well known. It's a very high quality seed. It's not cheap, and I think it's used quite frequently by the Connecticut DOT. This is a seed mix and a company that they actually buy from. So we feel very confident that it'll establish a nice wildflower area in front of the site. But with your comments, certainly we'll make sure that it establishes itself. I have a copy of the drainage computations and in my drainage area plan. I'm going to hand in for the record.
Just to let the commission know, Mr. Capaccione came down and talked to Jonathan and I, and he does agree with what the plan is, and he also agrees with the wildflower mix. He says it will look much better than trying to plant it or seed it there, right then and there. Just have the wildflowers come in.
Thank you.
Okay. Secondly, I also reviewed an erosion sedimentation control and restoration bond with Dave, and I've included silt fence and staked hay bales, anti-tracking construction entrance, spreading loam and seed on disturbed areas, and jute netting. And I've come up with a bond estimate of $71,075 that Dave concurs with as well. So I'm going to also.
And I received that email as well.
Yeah. What was that amount again, Mr.
$71,075. And I'll hand that in for the record as well.
Yes.
Okay, thank you. Lastly, there was some discussion regarding the grading near the railroad. John, if you could put up that second file that I included in there. So what I did do is I sent a copy of the plans and a letter to Tom. I can't even pronounce his name. Tom Krasowski. He's the Providence and Worcester Railroad manager contact in the area. I sent that to him back on May 6th, and I subsequently followed up with a phone call, and I only heard back from him today. Number one, I think the concern was that the proximity in which we were excavating near the tracks, there was some concern about it. If you look at the profile that I have on the right-hand side, on the far right on the profile, you can see the elevation of the railroad tracks, which is about 16 to 18 feet lower than the top of the hill to the site, and you see the existing grade and where we're proposing to cut. The one issue that we still have is that this grading is within 50 feet of the property line. And I discussed this with Mr. Kranowski today. He asked me to contact another gentleman in the company named Tom Ferris, who is the Director of Safety and Compliance. I did leave him a message. I have not heard back from him, but I do have a copy of the letter that I sent to Mr. Krasnowski that I'll submit for the record. The way that I read the regulations, it does not appear to me that this commission has the authority to grant me a waiver from another property line. You certainly have the authority to grant a waiver from the roadway if that were the case and we were excavating below the level of the roadway, but we're not. I might submit for the record, though. We're certainly. We are not at the level of the railroad tracks itself until we're about 125 feet into the site. We are maintaining and preserving that large berm that resides between the railroad property and the tracks and our property. I certainly understand if you would like me to continue to pursue some correspondence from the railroad in order to keep this grading. Like I said, I have been pursuing it, but I just haven't been able to get an answer up to this point for this particular item.
So who's got enough clout to get their attention? What kind of person? Like somebody in the governor's office? And that's just like off the top of my head.
I don't know. Well, like I said, I just got this other guy's number today. So, and it took a week and a half for Krasnowski to get back to me. I mailed him plans and left him messages, and he got back to me in about 10 days. So when he gave me that gentleman Tom Ferris's number, I called this afternoon, but I certainly didn't expect that I would be speaking to him immediately about it. And even if I did, I think he would probably want to see some plans or meet with me to review it. From an engineering standpoint, like I said, we're about 125 feet from the tracks before we are at the level of the tracks. We've got that significant berm, which is going to be 16 to 18 feet high between our excavation and the tracks themselves. But like I said, if I'm reading Section 560 correctly, and it's 560. Hang on. Yeah, 0.7 I2. Well, you got I1, I2, and I3. But it says, no excavation, no rock quarry conducted under a permit issued pursuant to these regulations shall be, 1, below the grade of any abutting highway within 150 feet thereof, unless approved by the commission. And the second, and it says, or, below the grade of any adjoining property at the property line within 50 feet thereof, or lastly, within 150 feet of any dwelling existing at the date of the permit issued. So, I think this, if I'm reading this correctly, this unless approved by the commission doesn't carry over to that item 2. But if you certainly want to interpret it differently, I wouldn't have any objection to that.
It's basically for 50 feet from the property line forward. He can't be lower than the property line, because we don't want anyone to undermine anything else. And I think that was the concern. We wanted to make sure that there wasn't going to be any undermining of the railroad, especially with it being a freight railroad. So.
If you're do hear back from the railroad and they were open to a temporary easement to match the grade, would that be the intention?
No, I don't want to match the grade.
Okay.
I want to keep it like it is, but your regulations say that I can't be any lower than the property line within 50 feet of the property line. It naturally is anyway. It already is lower at 50 feet. I'm just sort of, finishing my grading and kind of catching up to the grades at the top of the hill there. So, the only way to actually not be lower than the property line, I would actually have to fill there. But I think the intention is that there'd be no, even if the property's lower, I wouldn't lower it any further than what it is.
I don't think the intention is to have fill. I mean,
No, I don't
Yeah.
think so either. I don't think there's any intention to have fill, because, that's the naturally occurring grade that's out there right now.
agreed.
And the black line is the property line? The dark black line?
Yeah, that dark black line is the property line.
And
Correct.
so you're about, what, 35 feet maybe?
About 35 feet before that grading begins, correct.
And if the black line's the property line, where's the railroad itself? Is that
To
shown
the
on
far,
there?
to the far right on the profile, I actually have it labeled.
Would it help if I zoom in on it?
It's
Yeah.
about 25 feet to the right where those words are, I presume? Right?
Yeah. That slope from the railroad to the property line is pretty steep.
Yeah.
Yeah.
I mean, so the regs, when they were written, I mean, I remember they were intended so you weren't undercutting at the property line. I don't think we envisioned the far side of the property line to be lower than.
Yeah,
know,
quite
the
honestly,
other side.
quite
So-
honestly.
There's natural berm
When
there.
I
Right,
went
natural
back
berm.
and looked at it,
Yeah.
quite honestly, when I went back and looked at it, and I said, oh my, hey, that's right, they're a lot lower here then, so.
Yep.
If I may, Mr. Chair, I think as proposed, maintains at least that kind of like sound berm,
Yeah.
for whatever element of deadening the sound from the train, going, across
So the
Route
neighbors
12.
across the street don't necessarily.
I mean, it's still above. You're
No,
still-
I understood. I'm just
Yeah.
trying to figure out in the rules if there's a way for us to do a variance or a change to that.
I don't think it would be a variance. The
It
way
can't
it's
be a
written.
variance for the planning and
Yeah,
zoning
it can't be a
commission.
variance from
Sorry.
you
Yeah.
guys.
Wrong term.
Correct.
How's that?
An exempt-
Whatever you want to
or-
call it, exemption.
Yeah.
An exemption.
An exemption.
Yeah.
But it looks, and Norm, correct me if I'm wrong, it looks like it's matching the grade, even with the grade, as you do the grading, you're almost matching the grading down up to that 50-foot mark.
Up to that 50-foot mark, correct.
And then
correct.
beyond that, that's a moot point.
Yeah, I mean, it's real close. It's real close, because the property line and where the top of my grading is, that's about 35 feet. So if you go out the other 15 feet, technically, it is a little bit lower, at that point. Certainly not significant.
But it looks like it's still higher than the railroad tracks?
Well, 16 to 18 feet higher, correct. Yes.
I don't know if you can see my cursor, the railroad tracks are here.
Yeah, railroad tracks are about 218, and the top of that berm is about 236. It varies along the length of the property line, but it's anywhere from 234 to 238.
So if we go out the where the railroad tracks are, we're saying like the 218. If we follow that line to the left, no, go over to the railroad tracks, John.
Yep.
Yep.
You
And follow
out.
that line out.
It's about
How-
that's about 125 feet from the railroad tracks.
I think, I don't know, the commission would be the entity to say otherwise, but it sounds like that's within the intention of the reg.
I think that's what,
Yeah, and visual, I think, the visual is certainly helps out in understanding, what we're up against here.
If I may,
Yes, sir.
looking at this to the left, right,
Mm-hmm.
Closer to Jolly Commons, that's 237, right?
Mm-hmm.
And over at the far right,
About 234, well.
yeah,
it-
220.
It drops,
Oh,
it
yeah.
drops down as you get
Right.
to that sort of
So-
like where the property turns to that very narrow point, and most
So
of the
wouldn't you
grading
be
there is,
getting water coming down, once that's lowered to,
the way that the site is grading, there's no water going in the opposite direction. It's all coming onto our property.
that's what I'm saying.
Yeah.
But there's not going to be anything affected in the right-of-way for that rail line.
No, no, sir.
What's on, under 560.6? I don't know if you guys have the rules in front of you, but 560.6, we have an item C. Looks like a typo because I don't see an A or a B,
Oh, okay.
but.
I see, yeah, specific requirements may be waived by the P and Z Commission when, in its opinion, such requirement is unnecessary because of the limited size of the operation or other valid reason whereby the health, safety, and public welfare will not be adversely affected.
What number is that? 560.6, under
560.6.
application process.
Under item 16, page 8 of 15.
Yeah, you could see, okay.
You can see it. So I got it right there.
So,
Okay.
go-
I think the integrity of the railroad is the most important thing, right? And that's not being affected.
it is, but we're just gonna make sure we're complying with
Yeah.
the rules. So
Yeah.
the way I'm reading this provision, it gives us the ability to look at, again, the application requirements.
Right.
This being one of them, under 7, under performance standards, and looking at the ability to waive it, what do you want to call it? Given the fact that it's not undermining at the property line or the property on the other side of the railroad tracks. The intent was to make sure we had somewhat of a buffer from the cut to the property line, that we weren't undercutting the property line. In this case, the berm remains.
And I think that would, if you state that in the motion, if you make your motion, that the reason why, and that you're granting the waiver for these reasons, 1, 2, and 3.
I'm going to add to that, just mention the actual regulation, because I
Yeah.
recently saw a thing, we can't blanket say health, safety, welfare when rendering a decision that's outside your regulation. So you want to
Cite to that specific
cite to that
regulation.
regulation.
Okay, there was another provision too, to mark on the plans, the 150-foot setback to residential structures. Did you do that?
I did not do that. Nope, I did not. That was the one thing I did not do.
So we're going to be on hold with this anyway, right?
Appears that way, yeah.
Yeah. That's a sum total of this entire
We could,
conversation, is that we're not ready to move forward.
Could did you want us to bring up GIS? We can get a rough estimate off of our GIS maps. We can bring it up through our computer and show it up on the screen.
Well, we want to verify that, because again, that one you can do if you have written approval of the owners, right?
Yeah.
So, and that's really only, I believe, for the front piece that you have, because that's the
Right.
only place that's slightly lower than,
Yeah, I mean,
right?
is
Because of the
that,
drainage.
well, that's within, that's basically a lower elevation. The way that reads, within 150 feet of any dwelling, that means I can't be below the grade of any dwelling within 150 feet. So we are not below grade of the road.
No, on item 3. Within 150 feet of any dwelling existing at the date the permit is issued without written approval of the owner.
Right, but that's,
That's a straight 150 from your...
It's just general
oh, that's just with,
excavation.
not the lower
No,
elevation.
it's just
No.
excavation.
Just the
Any
flat
excavation
excavation.
within 150
Okay,
feet.
I got you.
So we got to verify you have at least 3 residences across the street. I think it's 2 or 3.
Okay.
So you have to verify from the I believe it's the way it's written, it's the residence itself.
Yes.
I
Correct.
can share the GIS if you guys want to see, at least from our GIS, 150 feet from the property boundary line. It's GIS, so it's approximate.
Yeah, I mean, the applicant's still going to have to demonstrate.
Okay.
Yeah,
Yeah.
I can certainly demonstrate that,
Okay.
but,
Yep.
yeah.
Okay.
And I think that was.
I think that was the final item, you know, and I went back to my notes, and apparently I overlooked that one.
And you updated the stockpile for the topsoil? You said it was too small, and
Yeah,
you
I just-
updated on the revised plan.
Yeah, just blew it up a little bit.
Yep.
Yeah, and then, and in talking with Mr. Jolly, he said that he's probably going to remove,
Okay.
you know, whatever he feels necessary anyway. He said he's not going to stockpile a ton of it on site, and
And is that cross-section that you showed on the drawings?
I included it in a, yeah, that you have a.
It's on these
It's
drawings?
in these drawings, correct, yep. It's included as a last sheet on the plans.
Okay,
Yes. It is submitted for the record.
okay. Commissioners, any questions, any follow-ups?
Sounds like we have time if something pops up in the middle of the night.
Well, just want to make sure we've got all the questions on the record for the applicant and Mr. T-Wall to answer.
So I think that would be the last item, though, right, the 150. Otherwise, I believe I've addressed your other concerns up to this point.
Everything I had on my list, you have. I'm not
Mhm.
sure about the rest of the commission.
Yeah, I've got it.
Yep.
I'm reading my notes now, and it's the first one. I was so concerned about the railroad thing.
Yep. Nope. Anybody from the public want to speak to this application? In person or online? Nope.
Okay.
No further questions from the commission, no further updates, so you've got, just to verify the 150,
Mhm.
and you've got the detail on there. I would recommend just on that cross-section, just if you can put the distances,
Okay.
maybe, just so the commission members see it.
Okay.
So if they do want to, include anything in
I-
that provision, just
I
so
can do that.
versus
Sure.
scaling it off.
Sure, I can do that.
Just from the property line over.
Okay.
And over from the railroad track, but those 2 dimensions I think would be helpful,
Okay.
so.
So at this point, we're going to continue the hearing until
And
June.
do we need an extension? Are we getting up against?
He
that
would have to
timeline?
approve it, but since needs to give us further information, I think he'll agree to that, correct?
Yes, I will.
Okay.
Yes.
Yeah, applicant will give us an extension.
Applicant will give us an extension.
All right, with that being said, can we have a motion to continue?
I'll make a motion to continue this hearing.
Thank you.
Our next regularly scheduled meeting, I believe, is June 20th.
June 20th, second.
All right.
I'll second that.
It's the day before my birthday, so.
We have a motion and a second. Any discussion? Being none, all in favor say aye.
Aye.
Opposed? None. All right, see you in June, sir.
Okay.
All right, item number 2, zone text change application 22-1287, Town of Killingly, special permanent use under business park, general commercial, light industrial, mixed mill use, and mixed use interchange zones for the creation of cannabis establishments.
Okay, just to let you know, if you look to your right, you will notice that we've had some comments from the public with regards to number 1B. And I'm going to let John talk to this because John has done the research.
Yep, so it came to our attention that number 1B might be somewhat problematic given the zones that are proposed in the regulation. So what we did was looked at other zones, namely the general commercial zone, to see what the buffer is, as well as some of the language in regards to planted screenings or other types of screenings. So a lot of this language is not anything new. It's from some of our definitions as well as from the general commercial zone, but it leaves a open door for the commission to require at least 25 feet of a buffer where the zone for the use meets a residential zone. So at least 25-foot buffer. It also allows for the commission to allow substitution for a hardscape, essentially, a wood fence, stone walls, or combinations thereof at the property line. So it reiterates the ability and kind of leeway that you have under special permit, but it just better spells it out, and it's better than that 200-foot buffer, because when we were looking at that 200-foot buffer, we were thinking more of the rural development zone, and it was kind of a draft item when we were talking about the rural development zone. If the rural development zone were to be included, that might be more of a in line with a conversation for that type of zone, but for given the general commercial zones and mixed use zones, we felt this language a little bit more appropriate for the 1B.
Because we also were looking at some of the zones and realizing that the 200-foot buffer could cross out particular areas of all these zones.
Large portions of
large portions of
yeah.
the zones, and that would be a problem if someone wanted to appeal it to the courts. So it'd be like, oh yeah, we allow it here, but we really don't. So that would not be good for the town.
So has this language been public noticed, 1B, or is that proposed?
It's a public hearing, and we're in our notices, we say the language can change without additional notification.
Okay.
And if this language was put into here and this was approved, we would publish it with the proper language. And again, that's why we ask for the delay when we do the effective date.
Right, but just so with public hearings, usually with zone text changes, something like that, we've got to be somewhat within consistent with what we public notice. So this one's less stringent, so is that acceptable? Typically, if we go more stringent.
It's no different than if during the public hearing other comments came up or changes were brought up by the commission to say we want to change this language.
Okay.
It's really no different during this process
than
what we've done before.
All right. And just so we're clear on what was public notice, so the addition would be the first page? into the
Yes,
zone
it's under
applications and the
number
definitions,
1,
right?
separation requirements, letter B would be replaced.
No, I'm talking about the whole application that's going out for public notice as far as what we're adding to the regulations.
Yes.
Is page 1.
Yeah.
And then page 2, definitions, and halfway into page 3.
Mm-hmm.
But that section where it says notes does not become part of our regulations.
No, that
Agreed.
does not.
Just,
It's not. It
Agreed.
stops.
The notes are just there in case during this process that came up,
Yep.
and also for a little bit of background, because this is new for everybody, this
All
type
right.
of use.
So notes will not be part of,
Okay.
Yeah.
Can
The
you
regulation.
clarify something for me? I know we had the discussion about growing marijuana, and that seems a separate issue to me than selling it somewhere in town. And so, just remind me where we're at. I thought we had
So-
done with the planting part.
So there is growth. Our moratorium prevented commercial, basically, application. The commercial application is for all cannabis establishments. And by proposing this covers retail and grow facilities. The way that this is written, grow facilities would be indoors. We've seen firsthand other towns where they did large hemp grows outdoors, and the smell that comes off that type of property. So we were trying to mitigate nuisance claims and other items for residents by requiring it to be indoors. Plus, it's New England, so an indoor grow seems more common sense with the winter.
we've done some research. Again, we've had other people have come into the town hall, and they have explained to us that in New England, it's much better to have an inside growth than it is to have an outside. it can be much more controlled, and it
Right.
helps with the security.
Yeah, I know we went through that. I'm more concerned about the sale of like shops in town.
So
Or you only get to have one.
we only have
one.
one retail,
Yeah.
one grow currently under the state stuff. They could change that in the future. Every legislative session, there's items in the language of the 300-plus page bill that was passed that kind of leave it open-ended that they might change it in the future anyways. Other types of cannabis establishments, there's a few that are not limited by the numbers. Transportation, some of the other uses that are identified in the definitions, like delivery service, food and beverage. Some of those have different ways that they're calculating the licensing, and I think in some of the cases, OPM hasn't even come out with all the policies on those yet.
All right, do we have any comments on the draft regs?
I can't find it, but at last month's meeting, we were given a draft of what we thought, the limitation should be for the sale for that one location in Killenly. I went online and found something, drug-free zone law, and this is published by the Office of Legal Research. And I spoke with an attorney at that location today. And what caught my eye, and it's got to be noted that this is December 1st, 2016 when this was put out there. And the reason I called him was I wanted to know whether or not any changes had taken place since this was published. And he took his time and really did a good job in looking at all these areas. And from what he could see is when the legislature passed whatever is out there now, directing communities to do what we're in the process of doing, there was nothing that addressed the existing law right now. And the thing that caught my attention, and this is what I advocated when we were talking about this, I thought that 500 feet was too low. And it presently stands at 1,500 feet, exactly what I thought it should have been, by coincidence, by the way.
So the 15.
So until this changes, and it was his opinion that the legislature will address this once communities decide what their limits are going to be, individuals, because that's what it's left up to. But it's at 1,500, and I still have difficulty in believing that, especially now, knowing that the state had 1,500, that we're willing to go to 500.
Can I see
But
that
the
document,
distance from a
please?
school or, yeah,
So this has come up on some of the state discussions.
yeah.
There are the people who have gone through the bill say that it is exempt, but I know it is a debated exemption. But my understanding is that is it exempt from the drug-free zone. But you're correct. Yes, drug-free zone is 1,500 feet, and they are leaving it up to the towns for the separations. The 500 foot is direct from the past bill, that it's 500 feet for certain types of items, like from a church. And when I don't have all the lists, I know we are.
Well, this is from schools.
Yeah,
It specifically says that, and I don't know what else. It doesn't cover all the things, I think, that.
So churches and schools, I believe,
Yeah.
are mentioned in the bill, and it's a 500 foot in the bill that got passed. The other items that we have listed in our section A, 1A, are in addition to. So that was a common element we were seeing from other municipalities, other cities, to broaden it to also be town parks, daycare facilities, other publicly funded entities. So that's why we added those extra zones, but the 500 feet I know is in the bill. I don't know the exact section. I'd have to.
In what
It's in the,
bill?
it's in the current bill.
The bill that made
Just recently
cannabis
passed.
recreational, essentially.
This was before.
Since our last meeting, they passed the bill?
No, no, no,
This-
no.
No.
No?
This, as you said, this was from 2016.
Yeah.
They just passed one, was in 2020?
He researched it. He told me there's nothing newer than what that is, right there.
Maybe for his,
And that's why he told me that
Research.
he thinks what the legislature is going to do, that once this thing progresses to the point where communities have established their distances, then they'll address this. But as it presently stands, it's 1,500 feet. And, you know, I think of off-track betting, for an example, when we had it. Zips had it. You know, it wasn't a good environment. You know, they got rid of it because of everybody hanging around. And then it moved to the black, which is presently the Black Dog up there. They had the same problem with it. I mean, it seems to me that 500 feet is awfully close if you put it to a school or next to a school, or, and I can't think offhand what other facilities you'd want to include in there. But even 1,500 feet isn't a tremendous distance. I mean, there's plenty of locations in Killenly where, and I don't think you'd want it right downtown. I don't think somebody running a restaurant or something would want that sort of a facility next to them. I mean, even though the school is 500 feet away.
I'm trying to look it up for us, John, but I know the town attorney did go through our draft language as it's submitted, and didn't
This guy
find
was an
issue.
attorney, and he works for that office. You know, that's right at the top. They're the ones that put out that document. And he told me today that that is still what's in place, and he thinks the legislature will address that once this thing gets legs and is implemented. But presently, it's 1,500 feet. And I thought it was,
if you excuse me for a moment, I can go
I thought it may
downstairs. I
not.
have a paper copy of the law. I'll bring it right up from my office.
okay.
All right. So I have a 2-minute recess. Motion for that?
Good.
Yes, a
Motion.
motion.
Please mute your mics, and I'll.
I'll second the motion.
All in favor? Aye.
Aye.
2 minutes.
Two attorneys in the room. Public hearing.
Coming up. That's coming up.
Yeah. But couldn't you say the same thing about like a package store, right?
Right,
If you are
There are, yeah. Only if it's open. I mean, I think just the way that you did, to be honest. I mean,
You all set, Anne Marie?
I understand
Pardon?
like what you're breaking up. I do, but I think it's just as easy for someone to say that it is
Try to keep it tight sheet.
Pardon?
equally as dangerous or
Oh,
not
okay.
dangerous as
I said 2 minutes. I want 3.
All right.
But there will be consequences for that too.
ordinance, I want to reference the, what do you got?
This,
No, that over there? The law you had, Judge Rizzo?
yeah, I handed it to her.
Oh, it's not that blue thing?
No. Oh, you did?
Okay.
Yeah.
Write down that reference.
Yeah.
It's the first one that pops up. Right? 2021. That, I guess that covers like everything. That's that covers. So I'm not gonna.
Pardon?
There's a 2021 report, but it's huge.
That literally, I think, that gives them the authority for if they have a suspicion for, I guess, any, like literally anything.
All right, so I'm going to say the thing anyway, but.
But did it address that one issue?
I mean, I think they should bring it up because I'm sure that some people have that concern, right? And we are the voice of the people, right?
Right. And we have that, I have that concern because I know damn well what I did.
Right.
So.
There's a chart that,
Oh, we're not ready to start yet?
I mean, we are rapidly approaching our 2 minutes, I'm sure.
All right, we're, 2 minutes is over. Back on the record, how's that? So, you got to unmute. All right, we're back. I feel like the judge on My Cousin Vinny. What do you got? So I just have not a quick question, but I just want to note, John, what you highlighted here, the 1,500 feet has to do with selling illegal drugs or committing sale-related crimes, which would be different than what we're proposing.
yes.
Okay, I just,
But I asked them if the state had changed that 1,500 feet because of now the fact that they're legalizing this thing for recreational use.
no, I understand it, but I'm
And
just.
it's still the
but-
same
but-
thing.
But our 500 feet wouldn't be in conflict with that if that law is related to the sale of illegal drugs, correct?
I don't know.
Well, just
know,
straight up face reading it without being a lawyer, there's 2 lawyers in the room, they
Yeah.
can speak to that, but they're not our lawyers. But you guys can speak to it anyway. But anyway, staff, do you have anything you want to?
This is a very long bill, but I do know that we had the same question, and we were told that it was the 500, but I want to be able to find the facts for you.
Okay.
Yeah, I have one more question. At last month's meeting, you mentioned that there was a difference between the application for Dayville Full Corners and the one for the,
Well, we're not there yet.
yeah, but why would one be permanent and the other would not?
We're not there yet. We're on public hearing for this one, so we can't, that one's coming up for public hearing, it's being pushed, but so we'll stick with this
All
application.
right.
So, do we have any other comments, changes, recommendations on the draft language from? Yes, ma'am.
We're talking about pot still.
Talk about the cannabis regulations. Yes.
That's what we're talking about.
I haven't moved to
Yes.
liquor.
Anyway, what I wanted to state is like, we've been talking about everything that's got to do with planning and zoning issues, which is appropriate for us. However, what I'm sitting here worrying about is, a lifetime ago, I was stoned driving in a car, and I think that having a store in
My
town.
kid's on.
I know. It was in Syracuse, and there's no cop that's going to come here and pick me up now, 50 years later. But what I'm saying is that it's not planning and zoning's job to think of this concern, but somebody ought to be thinking about that there's going to be people out there driving around in an altered state. Do I want to be on the road then? No. And I don't understand why we're inviting that risk to the community.
Can I-
We're not inviting that risk, no more. We're just passing regulations to make sure we have control, because our moratorium will expire eventually, right? So we need to make sure we
We've
have
got-
control of the zoning rules.
Just
That's the
to respond,
legislature's-
to you a little bit, there is already discussion among the authorities that would have that jurisdiction, likely the police and, criminal attorneys and whatnot. That discussion is already being handled by them. So that's well beyond our purview here for tonight.
Yes, I recognize that, but in terms of this town creating the structure for sale of the product, that by its very nature it brings up the issue of, well, what's going to happen with the sold product that puts the rest of us at risk. So anyway, we don't need to, drag this out tonight, but I just wanted that on the record.
So any other comments on the draft zone change, text change?
Yeah, I mean, I just had a brief comment on the 25-foot wide strip. And I'm just curious, I know that was based on the commercial zoning regulations, I believe. Is that correct?
Yep.
Yeah. I mean, I work in Providence, and there is a grow facility in Providence, and it's probably 25 feet from the street that I drive by on. And I'm sure that there are odor control systems in place, but I know even from driving by that, without even knowing before that it was a grow facility, so I would just be kind of concerned if this was going next to my house, basically, as a resident, and this is going right next to a residential district.
So,
you know what I mean?
So we did look at because we have order control measures, right, are being used, right, as one of the requirements. But what is the policy on that? Like this, acceptable, if you did an air quality test or projection or design in terms of emission. I don't believe those numbers for Connecticut have been established. So that's why it is somewhat open-ended.
Yeah.
But obviously, this type of license, they would have to show that there's. My belief is they would have to show consideration for those elements. Know that it's a requirement to meet all the state requirements for it. But similar to, just throw out like a chip manufacturer making smells. If they do hit the level in Connecticut, it could eventually trigger an air quality complaint with the state. That those items are beyond what we have even the ability to measure without the state being acting on it. So we're putting it in the regulations. I think it should be a part of the design process, and it should be items that an applicant should demonstrate that they're doing the consideration for. But understandably, there's no control in terms of a measurable level. A similar comparison would be our night sky compliant lighting. We don't regulate lumens. We have the ability to. We could put it in our regulations, but as long as the fixture is night sky compliant, I'm sure there's a gambit of different night sky compliant ones. But the lumens, obviously can differ, right? So we don't regulate the lumen levels. We don't have a way to measure it. So that's just a comparison for the smell. So is that a long way of answering your?
No, that's good. I mean, that was just it's. Distance is kind of king when it comes to dissipating odors and sound and light and all of that. Distance is the ultimate buffer, really. The farther away you can get something from an abutting property, the better off they are to be protected from it. So that would just be my one comment regarding that.
And keep in mind, though, under our special permit rules, 25 feet's minimum. We can always require more, given the buffers. I would like to see the language about the permanent structures to say in conjunction with the required plantings, because right now it's read as almost in lieu of or part of, versus I think we could always say we want a fence and 25 feet of planting. Whereas I think the language is a little loose. I would recommend in conjunction with as well there.
So approved in conjunction with the required plantings?
In conjunction with, or in lieu or part of, or all the required plantings. I mean, there's all the options depending on, again, what the adjacent property is. But at least lets people know that we may require both.
Okay.
If I could, Jonathan, I just
Yes.
heard what you said, and I agree, but I want to give you a couple of examples. Frito-Lay, for an example. The smell coming out of there is distinct, and it covers a wide area. Yet, because it's there today, I don't think there's anything in the state that can say, no, you can't admit that kind of a smell.
I believe they had an air quality action brought against them in the past.
And it's still there.
Yep.
And it's been there for 30, 40 years. The legislature said that we have to deal with this thing. So, you know, it's not our job to make a determination whether or not somebody's going to be safe on the road driving a vehicle. But we do have an opportunity, I think, to put this with a distance that's going to protect not only school children, but somebody that's in business that doesn't want this thing next door. That's why, you know, this is about the third time I've mentioned it. I think we should go from 500 to 1,500 feet. It's not an exorbitant amount of space, but it's going to give some space and protection in the areas in which we want it, rather than look at it 10 years from now and say, Jesus, you know, we created a nuisance in that area, and we've affected other businesses and everything.
Would you, going down that 1,500 foot, are you proposing that for all those uses that are listed, or only the ones that are like the schools and the other ones that are measured in the drug-free zones?
Yeah, I don't really remember all that was mentioned in school. I mean, schools was the big one. Did it say governmental buildings or something?
We have an expanded list of items compared to like a typical drug-free zone. So we have schools, houses of worship, libraries, public playgrounds, town parks, recreation facilities, daycare centers, nurseries, municipal buildings, or Board of Education facilities open to the public. And then we go on.
That sounds good.
Okay.
Any other comments? I have one more for 2, which we missed, but we should add a bullet that they need to address waste management as well. That's in the waste management industry, that's becoming an issue too with cannabis grows, on how they effectively handle their waste and their waste byproducts. So,
Like clippings and.
yeah, so it just needs to be a bullet there. They need to present that, in my opinion, present it as part of their application.
Okay.
What their waste management control strategy is or whatever, as far as how they secure it.
The waste management part? Okay. Jill whispered in my ear that it's regulated by the state, but it's fine, I think, if we include it as well.
Yeah.
As we have done in the past, we can always say that they need to give us a copy of what they've given to the state with proof that they've submitted it to the state for approval.
Okay. Any other commission comments on the draft text in front of us?
I think I would be potentially in favor of leaving the drug-free zones as written in the previous law, I guess, at 1,500, but the additional stuff that we've included as a town, I think could probably be set at the 500. I think it's kind of a compromise between both. That way we're addressing John's concerns, which I think are valid, and I think it also allows for enough space within the town that could still allow for feasible locations for a facility to still go in. So,
John, could I have that copy of that document back?
Of this document? Yes.
Any other comments? Anybody from the public?
Can I just verify?
Oh, hold on.
This-
Go ahead.
So that would be within 1,500 feet of the property comprising an elementary or secondary school or a licensed daycare center. Those are the 2 that they have here. Those are the only 2 that they have for the 1,500. Is the commission happy with those 2? And then they leave the rest of it at 500.
I'm okay with that.
Licensed daycare centers.
Any other comments? Nope. Anybody from the public want to speak to the draft regs? Anybody with the legal background? No. Nobody wants to go on record. All right. Anybody online want to speak to this application? Being none. All right. What's the commission want to do with the public hearing?
a motion to close?
Well, it can make a motion to continue, let
Can
staff
I just-
rework it, research it, and come back with the changes as recommended. So,
We could ask the town attorney for an opinion in regards to
Yep.
the drug-free zone element.
my
as well.
recommendation would be to keep it open, let that edit go to the town attorney, see what references the drug-free zone, see what it says. So at a minimum, he can come back and say, just put in that 1A section or consistent with state law.
Hmm.
All right, so whatever the state law is, then they must comply with state law. So it's a minimum 500 feet or as consistent with state law. So you could use that as language as well.
Okay.
Yeah, I'll make a motion to keep this open until next meeting,
Which is June 20th, 2022.
June 20th.
All right, do I have a motion, we have a second?
Second.
All right, any discussion? All in favor, say aye.
Aye.
Opposed? None. All right.
John, can I keep this? Can I keep this?
You can keep it, yeah.
Thank you.
Item number 3, special permit application 22-1289. That has been continued to June 20th, correct?
That's correct. We do have an email here from them requesting, they ended up having 2 separate hearings in 2 separate towns, and the other one they needed the people to be at, so.
Okay. Special permit 22-1291, Melting Point Welding and Fabrication, LLC, 543 Oregon Road, JIS map 262, lot 20, light industrial, 2.1 acres, manufacturing activities pursuant to Town of Killingly zoning regs 430.2.2B.
I know they all stuck.
I remember to turn it on this time, which was the mistake I made last time. Good evening, everyone. My name is Tim Bleasdale. I am a partner with the law firm of Waller, Smith & Palmer in New London. With me tonight are my client, Brian. If you just stand up and introduce yourself real quick.
Brian Kaya.
And our architect, Stuart Peasley.
Stuart Peasley.
We're here tonight on behalf of Melting Point Welding and Fabrication, Inc. And I just want to start out with a brief note. The cover page for our application gets the name of the applicant correct. They are Melting Point Welding and Fabrication, Inc., but for some reason the rest of our application refers to them as an LLC. So just to correct the record, it is an Inc. We were last year in October and December for a zone change on the property that we're here for tonight. That's 543 Oregon Road. Hopefully that wasn't me. And we're here sort of taking the next step on 543 Oregon Road. So let's see, I'm just organizing my papers. So Melting Point is a welding and metal products fabrication company. They're presently located in Plainfield, Connecticut, and we're here tonight seeking a special permit to enable them to relocate to Killingly. The building in question here is the old Benny's site, and our plan is to reuse that building, revitalize that building, and put it back into productive use. This particular business that we're talking about is classified as an ornamental and architectural metalwork manufacturing under the North American Industry Classification System. So for your record, if anybody's familiar with that, the code for that is the 332323. So a lot of threes there. But for everybody else, we have some examples of their work product that are in Exhibit 2 that were attached to our letter, and that should probably look familiar to a lot of you. We submitted a version of that when we were here in December. But to give a few examples, the sorts of products that they produce are railings, staircases, structural steel, ornamental fencing, that kind of thing. Now, the use that we're here proposing tonight is a manufacturing use, and that's an as-of-right use in the LI district under section 430.2.1A. Here, we have to ask for a special permit because the size of our building triggers that requirement in your regulation. So that's section 430.2.2B, which just says that an as-of-right use like manufacturing, if you're trying to put it into a building that exceeds 15,000 square feet, you need a special permit. So that's why we're here. Our building is about 22,000 square feet based on town records. And so that just is why we're asking for the special permit. Now the property itself is, as I mentioned, the former Benny's store. It's been vacant for a number of years, and so we're excited to be putting it back into productive use. You may remember that back in October when we were here talking about the zone change, there was a property owner from the neighborhood to the north there up on Carroll Ave, Ms. Lalibert, and she spoke in favor of the zone change, and one of the things that she mentioned was that she was concerned about that property continuing to be vacant and the sort of nuisance behaviors that it was attracting. There were folks that were trespassing there, sort of hanging out in the parking lot, kids doing donuts in their cars. And you know, us moving our business in there is going to put a stop to that sort of thing and sort of solve that problem for neighbors around this property. The property itself is 2.1 acres. It's a large property. It's fully developed. The improvements were approved by this commission when they were first constructed several decades ago. As I mentioned, the building, 22,000 square feet. It's got a large parking lot. It's on private well and septic. The property is zoned light industrial. And as far as the site goes, we are proposing very minimal changes to the site. We want to try to reuse as much as possible what's already there. The two changes that we are proposing are the creation of a vegetative buffer, which we're in part doing to bring the property in compliance with your regulations. So within the LI district, section 430.2.5 requires a vegetative buffer wherever a light industrial use is abutting up to residential property. So that would mean the creation of a vegetative buffer along Boregan Road and Lucian Avenue. And there are some existing bushes in that area, but they don't really provide that much screening. And when Stuart gives his portion of the presentation, he's going to talk a little bit more about that vegetative buffer. The other modifications that we're talking about for the site tonight include two sort of alternative proposals that we'd like to be able to do sometime in the next 5 years if they become feasible. We just don't know if it's going to work out yet, but the changes are all limited to changes to the loading dock. And so I'll get into that a little bit later in the presentation. Now, as far as the business itself, as I mentioned, we're trying to locate in the light industrial district. We came in and we changed the zone of this property in order to be able to bring this application tonight. And your LI district regulations specify that any use that goes into this zone has to be clean, quiet, free of hazardous or objectionable elements such as noise, odor, dust, smoke, and glare. And that's exactly what we're proposing here. All of Melting Point's manufacturing activities are going to occur indoors. And we anticipate that this is going to prevent it from producing any kind of no noise, odor, dust, smoke, or glare that's going to emanate from the property and disturb neighbors. Everything's going to be inside as far as the manufacturing process goes. There are no hazardous materials that are used in the manufacturing process. And the goal here is to implement a process of quality throughout all aspects of their business. So they want to implement this quality throughout their operations in a way that's going to minimize whatever impact they might have on the neighbors. And also, as I mentioned, put this building back into productive use, which is going to be beneficial economically to the town as well. Now, in terms of the size of the business, they have 15 employees currently. And what I think is meaningful for the commission tonight is that those employees break down into 3 different categories. So we have 3 office employees, 5 workshop employees, and then 7 field employees. So the fieldwork employees are not folks who work on site on a regular basis. They may come to the site to pick up tools or finished products, but they primarily work off-site at work sites, installing the finished products, that sort of thing. Now, as with any business, the total number of employees can fluctuate over time. We sort of expect that the maximum we may increase to in the future would be 25 employees. And that's going to be a mixture of fieldwork employees as well as shop employees. So any increase wouldn't necessarily all go to sending more folks into the site on a daily basis. And what I'm getting at here is the traffic that we're going to generate. So unlike when this site was a Benny's store, this operation is not going to be open to the general public. So you're not going to have people coming and going from the property all day. There are only 8 employees who are working on site every day, plus the president and the vice president. And beyond that, the only other regular traffic that we'll be generating will be due to deliveries coming to the site. So there's, again, 3 categories of deliveries. The primary one that you're probably thinking of is where does the metal come from that they work with? So that would be our steel deliveries. And this is another aspect of the operation that varies based on the demands of any particular project that they're working on at the moment. But generally speaking, we would expect 1 to 3 deliveries per week, sometimes more, sometimes less. There are weeks when there are no deliveries of steel. Consumables are delivered once per week. And then, on maybe once a day, there are UPS, FedEx type deliveries. Long term, some of the changes that we're proposing to the loading dock, our hope is to be able to move the steel deliveries entirely indoors for the offloading. And that's in part for convenience, but also mitigating any sound for the neighbors, getting the steel out of the elements. But in the meantime, the commission should know that typically offloading the steel deliveries takes about 20 minutes, sometimes less. So they're not frequent deliveries, 1 to 3 times a week, and when they do occur, the duration is short. The office hours are going to be from 7:30 to 5 on Monday through Friday. Workshop hours, 6 a.m. to 2:30, Monday through Friday. And the field workers' hours are generally 7 a.m. to 4:30. And again, those are folks who might come to the site to pick up a finished product or some tools, but then they go off-site. And this, as I'm sure you're all aware, that this property has a very large parking lot. And I want to make sure the commission knows that we're not proposing any kind of outside storage in the parking lot, which can be pretty common with manufacturing. What will happen here is that as products are finished indoors, they may come outside and be loaded onto a truck or a trailer, and they could sit there for maybe up to 24 hours or so before they're taken off-site for delivery or installation, as the case may be. But we think, as the vegetative buffer that we've installed grows to maturity and the trees get taller and all that sort of thing, it's going to provide a lot of screening to the neighbors as to any products that may be sitting on a trailer waiting to be hauled away. So I want to just sort of pause here and ask if there are any questions about the general business operations. Brian is here, and he can certainly go into a lot more detail about their manufacturing process if there are questions about that.
Commission members, any questions?
I just had a question regarding the increase in worker capacity. Is that based on the currently proposed building that's going to be here? They're anticipating an increase in workers, or is that for potentially in the future when there's an addition or whatever is proposed following this?
Oh, sure. No, I don't think there's any definite plan, but I'll let Brian speak to that. Oh, yeah.
Yeah, so as far as an immediate, I would say the worker, we're always looking for more workers, but probably we're talking 3-4 employees additional currently. And then the potential of up to, I guess it would be an additional 10. That's just kind of based on workload and whatnot in the future. Just kind of, that's an unknown, but basically right now I would say we're a little bit short-staffed, and the potential of 3 to 4 more additional employees.
Okay, so the 25 is based off of the current proposed square footage that you guys have of
22,000.
Yeah, 22,000. Okay.
It's a large building, and I think that was part of the attraction to this building, is it provides ample space for the company to grow within the walls that are already there. And I will say right up front, one of the reasons why that 25 number is in there is I just want to make sure that you know, we're clear with the commission about what might happen in the future. We don't want any surprises, you know. We're not sure that that could ever really happen, but, you know, we wanted you to know that that's about what we think might be the maximum possible.
It's Kaya, it's spelled C-A-Y-A. Yep.
John, do you have a question?
When you unload your material, are you going to have a crane or something outside of that dock area?
Yes, so our proposal for the immediate would be, we'd like to construct a concrete ramp so that the truck can come inside, because we intend to put overhead cranes inside the building for all the offloading. If we're unable to construct the ramp to get the truck in the building, we would end up offloading with fork trucks or whatever and bringing them into the building from there.
So you're going to up the grade on that loading dock that's presently there? So that you can drive right into it?
A concrete ramp, yeah.
Yeah.
Just at one of the
Yeah.
doors is what we're
So you're not going to be doing any unloading outside either?
That is our intent, yeah.
Okay.
Well, just to be clear though, is that your proposal now, or is that your intent now? So will you be unloading outside up front?
I mean, I guess it's our plans are calling for either the dock or an addition, or either the ramp or an addition, a fully enclosed addition. We just don't know if cost-wise if a fully enclosed addition is going to work for us for right now. But our full intent with approval is for the ramp so that we don't offload outside, because it just makes everything harder, more difficult for us too, if we've got to offload with a fork truck and then put it on some kind of cart and bring it in the building that way.
Yeah, no, that's why I just want to be clear, because I read it the other way, that you will be offloading outside with the potential of building a ramp. What I'm hearing now is you're going to be building the ramp for the get-go.
Absolutely.
And all unloading will be inside the building.
Yes, correct.
Okay.
If I could just interject to clarify.
Nope, he's the owner.
Yeah. Well, that is our plan, assuming that we get the approval to do that. And I can direct the commission to visual aid that might help with that discussion. On Exhibit 3 from our letter, which is this document, it's a general floor plan. To orient yourself, the top of the page there is, if you kept going that way, would be Warrigan Road, and off to the left is Lucian Avenue. And there's a projection coming off the building there right above the Exhibit 3 marker. And that's the ramp that Brian's mentioning. So we're proposing that as one of two alternatives that we'd like permission to construct when it becomes feasible. It sounds like the ramp may be the one that, you know, may be immediately feasible, but Stuart has another alternative that I think he'll be addressing in his portion of the presentation.
Okay. Yes.
I just want to let you know, they had told staff about the ramp, and I said, if you were to win Powerball tonight and not have any monetary issues, show us your Powerball plans, and then you can get approved for it, and then we will work with you when it goes through. So that's why this is
Yeah,
shown.
it's just the unloading inside the building. That's what I
Yeah.
want to make sure that it's.
They want to, right.
Couple follow-ups on employee parking is all going to be in the front of the building on the roadside?
Yes.
And employee access would be which area?
The employee access is going to be...
As far as cars, I'm saying, coming in and out of the parking lot. Because are you gated at every entrance?
We do intend on putting, there aren't any gates currently, but we
Right.
do intend on gating them, yes. So they would probably just be coming in off of the Route 12 exit
Not
entrance.
Lucerne Ave?
Correct.
Okay. And then on, for your indoor operation, do you guys have any proposed venting?
Yes, we've actually, we've got a plan for a system in place that's it doesn't extract anything. It's a full circulation system. There's, I think there's 16 units that hang from the overhead crane system. And it changes all the air and it keeps it OSHA compliant. And I believe it's five full changes per hour or something of all the volume of the air inside the facility.
So no exhaust, there should be very minimal exhausting.
Yeah, no exhausting. It should be all within.
Okay, and I assume the architect will talk about lighting when we get to that part.
Yeah.
Right? So we'll reserve that. I had the same question on the exterior lighting for unloading, so.
Yeah, one of us here is a dark sky nut, so I can't possibly.
Okay. So the letter that we submitted, beginning on page 4 through 8, addresses sort of point by point your special criteria, your special permit criteria, and I'm not going to waste the commission's time by going through that point by point. I just wanted to comment briefly on the just different aspects of your plan of conservation and development that our application kind of helps further. I think the remainder of the points that I made there would just sort of be repeating things that I've already said tonight. So the 3 sections that I wanted to highlight, the first is section 3.2, which addresses economic issues in town. And one of the policy goals that's set forth there is to help Killingly be competitive and to increase the quality, quantity, and diversification of employers in town. And I think this application pretty obviously furthers that by helping an existing business relocate from a neighboring town into Killingly. The second section that I wanted to just mention is section 3.5, which addresses land use issues in town. And one of the policy goals there is to encourage the redevelopment and revitalization of existing industrial areas rather than expanding industrial development into less developed areas. And again, I think this one's pretty obvious how we're contributing to that. Our whole goal here is to reuse the existing improvements and revitalize this property and put it back into useful, productive use. And sort of mirroring that is in section 3.6 of your POCD. That section addresses natural resources issues in town, and one of the policy goals there is to protect and maintain the undeveloped natural areas of your town. And again, that's what we're trying to do, is we're trying to move into and reuse existing property rather than breaking new ground and building a whole new facility. And I was going to end by talking about the generalized floor plan and that ramp extension, but we've already done that. And so I'm going to turn it right over to Stuart here.
Hey, just a quick question to clarify, because I missed it. So your hours of operation are different than what you had on Exhibit 2? So what you stated is going to be your hours of operation?
Yes, they should match. I'm just double checking here. No, that was my mistake. I misspoke. The hours that are listed in Exhibit 2 are what it should have said.
Could you just say that out loud?
Oh, sure. Yeah. They're not super different. So the office hours that are listed on Exhibit 2 are 7 a.m. to 5:30 p.m. Shop hours are 6 a.m. to 4:30 p.m. And then the field hours are 4 a.m. or sorry, not 4 a.m. 7 a.m. to 4:30 p.m.
Thank you.
And during shop hours, any excessive noise coming through? I mean, does anybody hear anything outside the building from any cutting, banging, welding, chopping?
I don't believe so.
Sure. If you don't mind,
yeah.
Like the guy who's doing the cutting, chopping, banging.
I think it's tough to say. It is a CMU building, so I think any noise would be minimal. I mean, we're not smashing things with sledgehammers. We're fabricating from scratch, so,
So tell me what a CMU building is before you carry on.
Concrete masonry unit.
Okay.
So it's a block.
Yeah,
Cinder block. So usually that kind of dampens the sound quite a bit, and I don't think I think we had some letters included in here with our current neighbors in Plainfield who have spoken to that. We don't make a lot of noise or anything like that.
If I may say something to that effect, Stuart Peasley here. I think that with the nature of the business, there could be cutting, there could be grinding wheels, there could be an occasional pounding, there could be some type of incident, but I don't think it will be consistent. to be annoying to the neighbors. And if in fact it were to become such an annoyance, that there would be acoustical measures that could be implemented to address that. So, and I think that Mr. Kay is willing to accommodate as much as possible. On that end, I'll continue. I'll start off just with the issue on the buffering, and that'll lead us into other topics. But I took a fairly stringent approach based on the buffering section 430.2.5, where it says we have to have the 25-foot width and the planting screen has to be a certain type, and we're willing certainly to, as I say, accommodate and be as least intrusive into the community as possible. But one of the questions we had is, I addressed by taking the width of the buffer line to the property line, and I'm wondering if we could not be held so much to the property line because we're adjacent to those existing planting areas, so that in order to accommodate the 25-foot buffer, we'd have to remove a significant amount of paving and re-landscape. So was wondering if there was any possibility of or flexibility on that buffering requirement located at the boundary line or within the existing green area that's there. It's also should be noted about at some points at the steepest part, it's about 10-foot differential in elevation. So from the road height to the parking lot finished grade would be about 10, possibly 11 feet. So the how that is significant is because the planting requirements or even fencing requirements is only 6 feet. So no matter what we do, let's say we were to plant arborvitaes, they're not going to grow fast that high like a white pine would. And if we put white pine in, then it's going to be, in 20 years, it's going to be possibly some kind of maintenance issue with the highway department. So, you know, we're at a point as to what is best to accommodate the regulations, but also be sensible with that location. So those are some considerations that I wanted just to bring up and put on the table with regards to the buffering area. Expense of the location, expense to modify the parking lot to accommodate that 25-foot width, or can we extend into the existing green area? And then what would the expectations be, what they would look like as according to the regulations with our planting type and or fencing?
I'm not the rest of the commission. I'm a little confused still. Where are you talking about? Are you talking about less than 25 feet, or are you coming into the property and then
Right now,
doing 25 feet?
that dark gray area is about 25 feet.
So you want to come into the property X amount of feet and then do a 25-foot strip?
It begins at the outer boundary of the property line.
Right.
So you're saying that,
I'm under the impression that there's an existing parking lot that goes within the 25-foot buffer. Is that correct? With
Yes.
what you're saying?
Yes.
So the existing parking lot goes closer than 25 feet to that property line?
Yep.
And he's saying that the side setback for a buffer zone in this is 25 feet, but there's existing pavement there. So if you look to I actually think it's easier on these drawings to see because it shows.
When you drive by on Warrigan Road, there's a grassy area there, and I think what Mr. Peasley is saying is that the pavement of the parking lot extends right up to the property line, more or less, and that grassy area is within the road right-of-way, or this is, but the prior owners of the building appear to have been planting bushes in that existing green area. And I
They
think-
were using that as the buffer strip.
Right, and part of the advantage to that is, as Mr. Peasley said, the grade difference between the road there and the parking lot, being able to plant into that grassy area helps raise the height of our plantings and provides better screening.
Okay, so what he's saying is, there's a road, the road right-of-way goes in, the green area right now is the road right, is actually the road right-of-way. So, like anybody's front lawn, your first so many feet actually is part of the right-of-way.
So it's a little bit of a question mark with regards to the buffering section, because it just says the width, it doesn't say where that starts. So that would be a clarification we'd like to look at.
What measures would you be proposing if this was to remain as it is right now? Are there any measures that you'd be introducing at the boundaries of the property or as close as possible?
I think we'd be willing to, or not, obviously willing, but we would like to put more planting in as much as we can within that area without a significant modification to the existing parking lot. That would be ideal.
Quick question. The area that he's talking about is the state right-of-way, so he would have to get a state permit, I believe, to have some sort of, if I am correct, I believe I'm correct, because they're right across, it's right next to the road.
Right, so you are talking on Route 12,
Yes.
Yeah.
not on Lucerne Ave.
Both we would be looking at. I was, yeah.
Yeah, because there's a 50-foot setback on one side, 25 on the other.
On Lucian, the existing green area is not wide enough to create the 25-foot, so pavement would have to be removed there.
Yeah.
And you are proposing to do that or asking not to do that
We're asking for a variance on that.
on both sides?
Well, whatever is reasonable. I think that, you know, the existing conditions there sort of are part of the consideration. You know.
I believe our definition of a buffer zone and what is required of a buffer, it does give us, the commission certain leeway on what they would require as a condition of the special permit. However, again, I just want to make you aware that Route 12 is a state highway.
Right.
And with that fact, that right-of-way, you would have to have some sort of permission from the state DOT.
I
And
think
good luck.
the same could be said for the town road. This commission doesn't have the authority to grant permission for an easement on the town road.
Okay.
But that definition that Anne Marie referenced, basically, it brings you to planted screenings, right? If you look up buffering, it's going to tell you to go to planted screenings. It's the last sentence of that. I have that up on the screen for you guys. It basically says that if an alternative is presented, the commission has the ability to allow it if they feel that it's appropriate substitution, provided that there's alternatives presented.
Yeah, if I could add, I think it would be reasonable as far as that goes with the setbacks, if we were to say just clear enough of the parking lot to say put a solid row of arborvitaes or something to that effect, and include that green space that's already there as part of that, because I measured today, we've got 27 feet on Warrigan Road from curb to curb. So if we came in so we don't encroach on the highway department's area for a strip of arborvitaes instead of a 25-foot strip of asphalt to be removed, but a strip big enough for the plantings, But that would also, you know, if you took the measurement of it, you would fulfill the 25 feet, but you would only have one row of trees. I don't know if something to that effect is a reasonable.
I think we'd have to show that in a drawing to.
Yeah, I mean, I'm stuck on the word arborvitae here because I recently bought some. And it seems to me that, you know, the place is down in a bowl. And that means that, you know, an arborvitae isn't tall enough to, you know, that if you're higher up, whether it's the road or, you know, it's like you're in a bowl. And the neighbors, you know, an arborvitae is not going to be tall enough to do what you want and the neighbors want and the town wants. So I'm not sure what kind of, you know, I'm not a tree person, but.
They will attain the necessary height over time. They will get that high. Eastern white pine will grow faster.
But it dies sooner.
It is more maintenance and more vulnerable to wind storms and things. But you know, in terms of just meeting the requirements in the code, that's, you know, that's kind of a hard distinction to make, I guess.
I mean, I think you need to look at your operation, the intent of it, where your activity is taking place along the front of it. Again, it was in Old Benny's. People are used to seeing that. It doesn't sound like you haven't got there yet, presenting any changes to the front of the building. It's going to be an office complex, people walking in and out.
I don't think that it's going to really make any significant difference visually.
So you need to look at that and propose whatever landscaping you think is appropriate there.
Yeah.
On the north side of the building where you're having deliveries come in and out, that's your side adjacent to the residential area, right? You need to look at landscaping that's applicable over there. That's the area there's going to be concern versus on the Route 12 side. Right, so you need to look at that area, what landscaping is appropriate to buffer those deliveries, those cars coming out, the workers starting. You know, you have your building on that side where it looks like your field guys are picking up supplies for the day. That's at 6 a.m. Your residential people right there, right? How do you address headlights, noise, issues with people coming in and out of that side of the building? Right, so whether that's fence and plantings, you know, something else, 25 feet, whatever that width is, you need to present something that's appropriate to handle that potential nuisance issue with that side of your building. So that's the intent of the buffer, is to buffer that side with the residential zone specifically. And I remember that being part of the discussion when you guys came in for a change, right? That 25 feet was something that we'd have the ability to protect the neighbors.
So based on what I'm hearing is that, would it be possible that we just put zones or areas instead of a contiguous line all the way around the boundary, that we would still be creating sort of features rather than trying to create this stretch of wall?
I mean, you need to look at the definition and try to meet the intent of the definition.
Yeah.
Right? It gives the commission some discretion.
Yeah.
But you need to try to figure out what are you protecting from, so when the commission looks at it and say, yeah, we think there's adequate protection for those neighbors. And when you look at the south and the west, I mean, you got a different neighbor structure.
I just think it's going to be a hard issue to address because of the height differential.
On the east.
Yeah.
Correct. But you're buffering against a state road. And I believe it's even commercial on the other side of the state road. There, isn't it?
It looks like residential.
There are residents.
Couple residents on that side.
They're set very far back in trees.
Yeah. Along that road is a strip of commercial. And then there's the international truck across the street from that.
If we could create something that would enhance the character and make it an improvement as to the existing conditions, you know, and just come back and make a presentation to that effect. Does that make sense?
Mm-hmm.
Okay.
Right. I would say yes for the commission, I think, for the most part, yeah.
Can I make a suggestion as well? I would suggest that you call staff, and when you go out to the site, staff will go along with you, and we can discuss it at that point in time.
Okay, sounds good. Other than that, I think the only point architecturally that I wanted to bring up was that this is, you know, a very exciting prospect just as a business from the commercial side. I wish we had more young entrepreneurs like Mr. Kaya taking these kind of endeavors on. This is very exciting to me. I wish I saw more of it in my practice. And with that being said, how that's demonstrated is the interior of this building is not generally, it wasn't designed as a production facility, but Mr. Kaya has got plans to go through and beef up the structure to accommodate that. And one of the features inside that will make it more of an internally based operation is that he's got a full cellar, which is going to really make it possible for him to store things that won't be visible to the public. And I think it's exciting to see how he can make this a really dynamic production process without making it a visual blight to the community. So I think it's a great opportunity for everybody. That's just my opinion. I want to put my 2 cents out there.
Mr. Chair, may I ask?
Yes, sir.
So, the parking regulations, we recently updated our parking regulations and do allow an applicant to propose parking based off the need of the use, not necessarily just the defined table that's in there. That's just kind of more of a guideline or a default to go back to. Is the, let's see what it is, 97 parking spots needed for this? Okay. So when we're looking, and I understand like maybe it's more of a cost element, like going into the pavement area, but I think if you base your parking requirements more off the need of the structure and have some reasoning to demonstrate with that, you could show an alternative based off of that with in terms of layout, and it could open you up to other layouts.
Yeah, I think there's definitely a lot of possibilities.
Okay.
Any other comments, questions? Nope. I'd ask the public, but we have none. So, any other guidance for them? I believe they're going to come back.
I think it's fair to say that we're all in favor of the proposal of this, I think. I don't know. I'm at least speaking for myself here. I think it's great that we're reusing something that's currently vacant and, you know, giving it new life, which is great for the town, the area, not developing on undeveloped land for the town. So I think that this is something that the town really is in favor of. We just want to we're just here, you know, ensuring that the people around are as well in favor as we think it is for the town, so.
Could I just ask, you briefly mentioned lighting concerns. I just want to make sure that we address whatever concerns there may be with our revised plans.
Okay, so a dark sky initiative means that if you have lights going upward, you're blocking out the stars at night. So there are light fixtures that aim the lights downward.
So you didn't get into your wall lighting, your exterior lighting during early morning hours. I assume you're not going to really have parking lighting. I don't know if you will or not, but just look at, be cognizant of what you're placing in the exterior side of the building, lighting up your loading ramp, your employee entrance, et cetera.
Yeah, I don't see any need for upward lighting.
Nope. And I would just present details on that at the next meeting, and just what you're proposing for lighting.
Okay.
And again, please feel free to reach out to staff, because we can have a meeting and we can discuss all this at once.
Good. Sounds great.
We will.
Thank you.
All right, so can we have a motion to keep the public hearing open till June 20th?
I'll make that motion.
Thank you. We have a second?
I'll second.
All right. Second, any discussion? All in favor, say aye.
Aye.
Opposed? None. All right, thank you. All right, number 5, zone text change 22-1292, Town of Killingly, allowing garages as a primary use in a rural development and low-density zones only.
I mean, I'm looking at the track record. I have a feeling it'll be continued, but we'll make an effort. We'll see.
8 lines.
Is this why Keith
Yeah.
didn't show up? Because he knew that this was on here today?
Yeah.
Is that why?
This is kind of this is his
this
brainchild
Yeah, right.
too. Yeah. So I mean, we previously had a workshop on this.
Yep.
The only language that has changed from that workshop to now is instead of being 1,000 square feet, it's 1,200 square feet. I don't think there was any real other changes that got brought into it, other than what you see in your packet.
Right,
So-
we added some changes at the bottom to make it a little more consistent with what was out there. Just that this becomes a primary use in those zones.
Yep.
So it's not a special permit. So, again, we looked at it at the workshop last meeting. We all agreed on the language and changes.
Okay.
So I don't know if anybody has any
And-
additional comments or changes they want to make.
And I don't see any citizens on this. I don't think we received any comment
Keith and
on
Colin?
this as well.
He's still got time.
You still got that?
Yeah.
Commissioners, any comments, questions on the language? So what do we want to do? No edits?
Yeah, I mean,
No public comment?
No comment.
All right. What do we want to do with the public hearing?
I'll make a motion to close the public hearing on this specific, I should read this, application here.
All right, we have a motion to
Yeah.
close the public hearing. Do we have a second?
Second.
Where is it?
Second by John.
Yeah.
Any discussion?
So we're talking about 22-1290.
2.
Yeah.
Yes,
Yes.
the last one.
All right.
Yep. So we have a motion and a second to close the public hearing. So.
All those in favor?
You're good? I'm just making sure you're good, because you said no. All in favor, say aye.
Aye.
Opposed, none. Look, we closed one.
There we go.
All right. All right, unfinished business, 1, 2, 3, and 4 all got moved or continued. Number 5, zone text change application 22-1292, Town of Killingly, allowing garages of primary use in rural development in low-density zones only. What would the commission like to do?
This is 5?
This is 5, so adding the garages as a primary use in a rural development zone, in low-density zone.
So we'd be
Yeah.
looking for a motion
Yeah,
and
to
then,
approve.
and then,
Motion
to
and
dis-
time,
then
if you want to
discuss.
approve.
If you want to approve.
I'll make a motion to approve the zone text change application 22-1292 as revised and effective.
Bottom of the blue page. I can't, June 13th, 2022, 12:01
There you
a.m.
go, exactly that time is when.
So, and just to be clear, as revised, as presented, because we didn't
Yes.
make any revisions.
Correct.
Okay.
Right.
Yep. All right, we have a motion. Do we have a second?
Second.
All right, we have a second by Verga. Any discussion? I don't, are we supposed to do a roll call for these? I don't know.
Ideally.
Oh, ideally. All right, roll call.
Vedka Lawrence.
Yes.
John Serentopoulos.
Yes.
Matthew Wendorf.
Yes.
Brian Card.
Yes.
Motion carries unanimously.
We should put down Keith as yes in nature. In spirit.
I think we know Keith wanted it.
Yeah, right.
Yeah.
Spirit. All right, new business, bylaws. Does the commission want to schedule a time limit for meetings? Do they want to allow a meeting to continue for additional hour, provided someone makes a motion? Review, discuss this meeting. Any formal action take June 20th,
This is,
so.
I went through this is because of what we were happening with the extended meetings we've been having. I did go through the bylaws. The bylaws do not have a deadline, so to say, or an end time. So what was proposed, and I want to make sure that this is still proposed because I have to notify all of you for the exact changes that we want to do. So let's discuss those tonight. So I think we were thinking of trying to end meetings by 10 and then have somebody make a, what?
Thought it was 8:50. and we're-
8:30?
We're right
Is
up
that what
against
we
that.
said?
You're killing my average. That's all I want to say.
So, you know, actually tonight, when I came here tonight, I'm like, wow, we're going to be really busy today. In June, we're going to have all this time to go through the riparian buffers and all this stuff, and then everybody gets continued to next month. But But this is.
We did pass one when you were out of the room. I'm just,
Oh, yay, that one got passed.
that got passed,
Mhm.
yep.
Yay.
Okay.
So we used to have like kind of an unofficial rule, right?
Yeah, did you-
At 10 o'clock or whatever it was, that we would say we'd go for another hour
Okay.
or two.
Well, let me know exactly what time it is that you want to have, make it official rule. Maybe cut it in half, 9:30.
Okay, but let me ask a question.
What?
Before. So, someday we're going to have much longer event, meetings,
Mhm.
and we are legally required to
You
do
have a
these
certain ti-
things.
You have a certain time frame that you have to start, you have a certain time frame that you got to start your public hearings in. You have a time frame for the public hearings to continue, and then you have to make your decision within so many days. So I'm going to tell you, on average, you've been doing really good. Because usually you receive them 1 month, we have the public hearing, we usually close the public hearing that night, and you've usually made your decision. So that's,
Right, but there will be a day coming when our agenda is way longer and that we're legally mandated to, we have a...
at that point, this is why we're trying at this point in time that we're putting everything in numerical order. And I know whatever the file, that's the oldest file, is there. And that's why I keep track on our, I haven't had to do it necessarily, but I do it with Frito-Lay. You'll say, you notice I'll say continued from such and such, continued from such and such. So we already know when you get here on the agenda, you already know it's been continued for 2 months. So you know. But you also have to remember, like, tonight we had a continuation, and then it was already continued from last month to this month because he was missing something. And so this month we really should have been able to close it and possibly made a decision. Well, he realized he did not give us all the information, so he agreed to another extension because we have an extension for a full grand total of another 65 days. So, you know, we will have leeway that's built into, you know, by the state statute, but we've been doing very good, you know, through our approvals process. So that's all I wanted to know, because I think that's what everybody was thinking. It's like, unless you publicize it and you say this is part of our bylaws, this is part of what we do, and, you know, we'll put it out there, and I will stop putting it on the agenda, you know, by our bylaws, we have to close, you know, we can, say at 9:30, we have to extend it for another hour. You know, a motion has to be made to extend it for another hour. That puts the general public on notice.
Okay.
So is there a time? Don't say 8:25.
Well, did that work well? 10 o'clock? I mean, that was the understanding.
It was the understanding. I mean, I thought 10 o'clock was fine.
Okay, so 10 o'clock, we'll start putting it on. I'll put it on the
10 o'clock.
bylaws for 10 PM.
I don't agree.
Okay.
For an allowed extension of 1 more hour?
Oh, no, I think we should
I think we
go-
can vote on how many hours.
Yeah,
We
I
want to be
think
here till
so.
1 in the morning, right? We could do that.
Okay, but if you want to say that your advertisement, if your agenda's going to end at, like, if your 10 o'clock is going to be a meeting, then we have to put in the bylaws that by a certain time frame, we would have to make a motion to extend it.
To extend it.
Right.
And at that point in time, we determine if we're going to extend it for an hour or until the end of the agenda.
Right.
Yeah, they would have that option.
Okay.
Right, either
So
hour
if
at
we're
a time,
saying,
but-
if it's saying 10 o'clock, we should probably make the motion at 9:45.
As long as somebody remembers. to make the
It will be
motion.
on the agenda
Just
from now
remember,
on.
you can always do a motion to adjourn.
That's right. You can throw it on the
I'd
table
like to make
anytime,
'em-
Matt. Anytime, Matt, you can throw it on. I just don't want to be that commission that, like, says, has a room full of people for a highly contested hearing, and all of a sudden, like, 10 o'clock, gotta go, right?
Yeah.
No.
it's- We want to
But I think it also gives people
notice,
notice.
right, lets them know that there's.
That
a-
if there was, well, there's also, you could
So if they
always
know.
figure it this way too. If it was, say, if we, all of a sudden, we were to get a storm, like there was, Western Connecticut is getting tornado warnings right now. If we were to get that, we'd be like, hey, guys, we get a break, goodbye, we'll see you next month. You know, but it gives people a notice that it's like, we try to get everything in by 10, and then we start telling people when they start building up the applications that as long, you know, it looks like, oh, we have 5 public hearings, your public hearing number 5, we may not be able to get to you, and this is the reason why. because it's in our bylaws and whatnot, so.
Yeah, I think 10's fine.
And I think to Virga's point too, like if we were ever at a point where we have like 50 items on the agenda because we're just booming, you know, Tesla's opened their third plant
Gigafactory.
here or something.
Don't start rumors.
You know, then
They're for the environment,
then
but
we
okay.
would probably have the conversation about having more than one meeting a month.
Yeah.
Probably just to split
And
it up.
that's something that we can always do. We can, if we have to close a meeting, if we close a meeting and we still have a lot on the agenda, we can always set a special meeting date.
Yeah.
So.
I think it's fine.
Okay. 10
All
o'clock,
right.
we're all in agreement. Let's keep this
10
in
o'clock?
consensus.
10 o'clock.
10 o'clock. Great.
Who has a
Is this
que-
one of those things where you have to have a certain percentage of votes of the commission to continue? No?
No, it's just,
Just
again, it's just a majority.
Keith doesn't have that many votes.
Stop.
All right. Opt out.
Okay. This is another item that I want to bring forth to you. We already have a secondary dwelling unit regulation, and it's much more encompassing than the accessory dwelling unit that's required under state statute, so we can opt out of the state statute. I want the general consensus of the commission that yes, this is, I think we already had done that yes, we want to opt out because there's a formal process we have to follow. So,
Well, we would like our own.
we already have our own.
Yes, we have our own and we like it, and if we have a way to go out the back door because of that.
Okay, so I will have something prepared for next month on that one as well. Okay.
All right. Adoption of meeting minutes, regular meeting minutes of April 18th, 22.
Those meeting minutes you will have to table until the next meeting. We have come to the realization that apparently there's supposed to be 13 pages and you only received 10 in your packet, and I don't know why.
Really?
I was
So you
wondering
can't-
where the last 3 pages were. I was looking for
Actually, read it
them.
and highlighted those suckers.
So full of it.
I was reading through and I said, that's it, the conversation's over?
So,
All right,
well, I'm not
tabled.
sure. So that has to be tabled to June 20th?
All
You want
right.
an official?
Yes, please.
I make a motion to table.
A motion, second.
I'll second the motion.
All right, we're seconded. Any discussion? There being none, all in favor, say aye.
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 Opposed, none.
Okay.
Correspondence? None. Didn't see any. Department reports? Didn't see any.
Well,
In
we
there?
have,
What about that miscellaneous item?
What miscellaneous?
oh, the 5 Mile River, we're still in the process of that. I have
It's a
found
staff
some more
review.
information.
It's staff review still in progress. I
Okay.
just skipped it.
See you.
All right, economic development.
Where to start? There's a Cannabis Industry Expo, May 20th to the 21st at Mohegan Sun. It's open to the public if you want to learn more about the industry. You brought up the unspent product that's heavily regulated as well, yet there's a possibility recapture manufacturing with that product. So if you're interested, it's my understanding there will be no...
Excuse me, what did that sentence mean? You capture, I mean, that whole thing, what are you talking about?
So once you grow a plant,
Yeah.
it's highly regulated. The plants are counted, the buds are weighed, the seeds are counted. And then if you have a plant that's aged out,
Yeah.
that is regulated as well. So they have to weigh it, there's a proper disposal process. Having said that, those plants can be made into other products for manufacturing. So it can be made into insulation,
Fabric.
plant containers, that kind of
Right.
thing. So if you want to learn more about the industry. I thought I'd bring that to your attention. We signed the letter for the Brickyard Plaza. That was that DECD Community Challenge Grant that Killingly was awarded. So we signed the paperwork today. We have 3 years to complete that project. There was 2 ribbon cuttings, one for the Burroughs Brewing Company at 31 Furnace Street. Market research says the beer is good. And then we had a nails lounge and spa open at 750. What's the name of that one?
Route 12,
Route 12, I'm sorry. So.
Upper Maple Street.
Upper Maple Street.
Or, sorry, Upper Main Street.
Upper
Or
Main
North
Street.
Main
North
Street.
Main Street.
North
Yes.
Main. North.
Make up your
I'll get it
minds.
eventually.
Yes.
I'll get it.
One
I'll
of
get it
those
eventually.
roads.
North Main Street.
Take your pick.
Yeah, because that's after the break. The borough. After the borough comes north.
She was a Killingly resident and moved to Massachusetts and came back and decided to open a business in Killingly, so.
And what is the business?
It's a nail salon.
Oh.
Yeah, it's gorgeous. And then we enrolled in the Brownfield Technical Assistance Program through UConn. They're going to give us a grad student to help us fill in some gaps with the Prim Mill. Also, 140 Main has overcome their final hurdle with SHPO, so you should start seeing some activity happen there. Came down to what kind of windows are you going to use. Also, the Economic Development Commission recommended the creation of a subcommission called the Cultural Commission as an advisory group to create a cultural district for Killingly. And finally, the Economic Development Commission submitted a proposal to do a Phase 1 and Phase 2 on the town-owned property of 125 Alexander Parkway.
John is here for those other 3 reports, if you want to talk to him.
No. Anyone want to talk to John?
Is everything in
Not
order?
you, John, not John.
Town's still here. Found North Main Street.
Excellent.
All right, thank you. Town council report.
From our meeting from last Tuesday, there were several presentations, proclamations, and declarations. Proclamations supporting law enforcement, Motorcycle Awareness Month, Foster Care Awareness Month, Lyme Disease Awareness Month, and National Military Appreciation Month. David Izzo was reappointed to his commission, which he's been on for...
Zoning Board of Appeals.
There we go, that's on my other page, for several years. We voted for the revenue collection to suspend and transfer uncollectible taxes to the suspense tax book. These are taxes that either the residents have died or have been unable to find these people. Mahoney and Sable and Company, certified public accountants, were approved to perform an audit for fiscal year 21-22. It should have gone out for RFP, but the quotes have gone up substantially, and Mahoney and Sable have been very good to the town and very thorough, so they're getting a good rate. So we will keep them for this year. We also agreed for a 3-year budget stabilization agreement with Connecticut Interlocal Risk Management Agency, KIRMA, which is Killingly's liability, property, and auto insurance carrier. It's a self-paid through several municipalities, and I believe last year they received like a refund of over $50,000. And the referendum vote for the town and the Board of Education budgets were approved. There was very poor turnout. The town budget, there were 342 yeses and 215 noes. The Board of Education was 299 yeses and 259 noes, although we don't know, because the budget passed, we don't know if the noes were too high or too low, but very poor turnout. That's it.
What's that, like a 8% turnout, 5% turnout?
It was about 5%.
Nice.
So maybe you should find some mother like
They're
I
all
used to be to
screaming,
make
hollering,
phone calls to
5%
parents to get out the
Well, you
vote.
can't scream and holler if you know. vote.
I used to help you with those.
Oh,
Yes.
All right, yep. Any questions for town
Right.
council?
It's a way to get out the vote.
Yeah. None?
I'd like to make a
adjourn?
motion to adjourn.
Yeah.
All right, that's
Second.
second. All in favor, say aye. No
Aye.
discussions, aye. Great.
Listen, I know that this is.
9:05.